meeting to order at 6:30. May we have a roll call?
Commissioner Bernardo? Commissioner Brennan? Here. Commissioner Chancarelli? Present. Commissioner Lorenz?
Here.
President Matoush.
Here. Do we have any public comment? Not seeing any slips. Let's go on to item B, California Public Records Act workshop, followed by adoption of a PRA policy. Mr. Miller.
Yeah, we'll do the presentation. That'll General Counsel Miller will go through the Public Records Act and some of the things that we'll be addressing, and then when we switch to the policy, I've got a staff report that I'll go through on that.
I have a question. Why were we not provided with this presentation in advance of the meeting?
My experience is that presentations, I know that speaking personally, presentations are constantly sort of getting tweaked right up to the last minute. So we can certainly put this on the website after the meeting tonight.
That would be great, but going forward, I'd really
We
appreciate
can do that.
seeing the presentation when we get the staff report as an attachment.
Yeah. Okay.
So the idea was that to help guide much of this meeting, your general manager, I thought it might be helpful to have not just an overview of the Public Records Act, which many of you have received before in trainings from various seminars, but to focus on this recent Supreme Court case that has influenced the need for an update to your Public Records Act policy. But at the same time, I thought it would be helpful for all of us to use that California Supreme Court case sort of as a filter through which to remind ourselves of some issues of the Public Records Act that have not been changed, and it's never get too much training, and in fact the Supreme Court advised agencies that the best way to comply with its holding is to make sure that it holds periodic training. So in having this session, we are in part complying with the ruling of the Supreme Court. My idea is, if I've timed this right, this is about 10 or 12 minutes. I'm happy to make it longer if you guys have questions, but this is not intended to take up our entire evening tonight. So, but you should feel free to ask questions as you like, or you can wait till I'm done and as you wish. So the starting place is just to remind all of us that anytime you're talking about the Public Records Act, you're talking about the California Constitution, which enshrines the public's right to access and implements the Public Records Act, which is located in the Government Code. And it's always helpful to remind ourselves of that constitutional right of access to public information through which everything having to do with the Public Records Act should be viewed. The specific case that we're talking about was handed down by the California Supreme Court at the beginning of March. This was a request to the city of San Jose about 5 years prior to this that sought, and you see on your screen the exact language of the Public Records Act request. Voicemails, emails, text messages sent or received on private electronic devices. The city took the position that since it did not prepare, own, use, or retain the records, and they sought records of the mayor, city council members, staff, and the city focused on the location of the record and stressed that since they did not possess and have control, use, or retain these records, they were not public records. And the city further said that the privacy rights of these individuals was of such utmost importance that those privacy rights trumped any agency obligation to comply with the Public Records Act. Even in the event that these records were determined to be public, they should nonetheless be exempt because of individuals' privacy rights. The court categorically rejected the city's positions. The city lost at the trial court, appealed, won at the appellate level, and then at the Supreme Court level lost again, and that's the last chance they get. So this is now the law, and it's worth, even though it's on your screen, it's worth reading. Here we hold that when a city employee uses a personal account to communicate about the conduct of public business, the writings may be subject to disclosure under the California Public Records Act. And I want to just caution you, yes, sure.
In that language, it says may instead of are.
Yes, so, absolutely. So all the exemptions that apply to agency records apply regardless of whether they are used in a personal account or a public account. You don't lose the exemptions just because you're communicating by a personal device.
Okay.
Does that answer your question?
Yeah.
And the other thing I want to point out is that this quote says a city employee, but there's really no question but that this holding applies to officials, employees, elected board members such as yourselves, general manager, me, everybody in this room. The court uses, it's just frankly a little bit sloppy. Sometimes they say officials. This particular quote, they said employees. The facts of this case involved records from the mayor. So there's really, as we go through this evening, if you see other quotes where it says employees, sometimes you'll see officials. I wouldn't read anything into that. It applies to everybody in this room except maybe the members of the public.
So just to follow up on that, so what you're saying is that someone could put in a PRA request for our attorneys' text messages and all communications.
Someone has.
Personal text
And I have
messages.
provided, if as you'll go through, and this emphasizes Commissioner Lorenas' question, if they are public records, they are subject to disclosure, even if they're your consultant, your harbor masters, your
Like a contractor working for the district.
correct.
Okay.
Okay, so how did the court get to this decision? And I think it's interesting and again worth reminding ourselves, they really actually applied the traditional public records analysis, which defines a public record as having 4 factors. In order to be a public record, it must be a writing, must have content that relates to the conduct of the public's business. It has to be prepared by or owned, used, and retained by a local agency. And the court went through this 4-part definition and applied it to the facts of personal communications on personal accounts and personal devices. And we will go through that together. So writing, they did not change any law having to do with what a writing is. A writing has always been defined in the Public Records Act as including electronic communications. No change in the law at all. Relating to the public business, again, no change in law. Whether a communication relates to the conduct of the public business is always a judgment call as to whether the writing has a substantive connection to the conduct of public business. And we'll talk a little bit later in this presentation about how all of us now are obligated to exercise that judgment to determine whether it has content relating to the conduct of the public's business. But nothing changed in terms of that analysis. Nor did anything change in the third part of the test, whether it was prepared by a state or local agency. Jurisprudence on the Public Records Act has always indicated that a disembodied government agency can't prepare a record, and only human beings can prepare a record. And so it takes an agency employee or official to prepare a record. If someone submits a request for all district communications about ice cream, an email from the director of ice cream management is a district record, even though it was created by a human being, not by the agency itself. So there's been no changes, and it's just indisputable that electronic communications prepared by officials and employees are prepared by the agency as used in the Act. The only thing that has changed as a result of this law, and I say only because it's a big deal, is the use of the word retained. The court, and it did so in about 5 pages that would make this presentation longer than the 10 minutes planned, but the court emphatically held that a writing has been retained by the agency, even if the writing is located on the official or the employee's personal account. Happy, if you want to know more, we can talk more about it, but the ultimate conclusion is undisputed that, and this is where the law now changes, because ultimately where the record resides doesn't matter. The only thing that matters in determining whether a record is a public record is whether it relates in some substantive way to the conduct of the public's business. Now, there then may be some exemptions that apply, but the first analysis is, does a record relate in substantive way to the conduct? And as I indicated, that is the same analysis has always applied. And again, we'll talk about that in one moment. The court then further talked about the city's privacy arguments, and implied that public officials, by dint of their public service, have some limits to their privacy and First Amendment protections. Public officials file contribution reports and gift reports, giving information about themselves. There are the Brown Act places limits on the ability to speak freely outside of the confines of a noticed meeting, and the court held that the Public Records Act, the rights of the public to public records, is more important than the privacy rights of individual members, especially given that the court found that there were sufficient ways to protect the privacy rights of individuals. And the two primary ways that the court suggested that privacy rights could be protected is one, through training such as this, the idea being that public employees and officials will avoid using intermingling public and private, and keep their private business private, and not use a personal account, for instance, to conduct their public business is a good way to avoid this. And that, since this case first hit the lower courts now 5 years ago, that's been best practices that we've all been trying to do as best as we can. So again, how do you tell? Now this is the thing I said I would talk about. The key factor is whether a record relates in a substantive fashion to the conduct of the public business. And the court reiterated a multi-factor test with no one factor controlling the analysis. You look at the content of a record, the context, the purpose of its being written, the audience to whom it's sent or received, and whether the author was acting within the scope of their duties in preparing or receiving the communication. And it requires judgment to balance those factors. Under certain circumstances, some may become more important, some may become less important. There is no black letter guidance that anybody can tell you. Common sense is ultimately a pretty good guide. So I thought we would take two examples. President Mateusz, it's up to you whether you want to take questions from the public at this point or not, but Mr. Olin is.
Is there a point I could ask questions? I don't need to do it now.
Okay, well, let's just move on then.
Okay, so I've got two fake emails for us to walk through and consider how I think a court now would analyze to what extent these are public records. Here's an email to the Gmail account of a staff member from a commissioner writing from his or her official harbor.com email. So first of all, remember the location of the record doesn't matter anymore, so this email will reside on the Harbor District server. That doesn't necessarily mean that it's a public record, it just means that it's easy for the Harbor District to access it because it's on the district server. I'd like to meet you a bit later this week. I know you're still recovering from surgery and imagine the pain meds are still making you groggy. Enjoy it while you can. I'm trying to understand all of our new Public Records Act requests and want to consider whether the new Supreme Court case indicates that we should be adopting a new Public Records Act policy. So, I made this up. This is obviously not a real email. There are parts of this email that have to do with an employee's medical condition. On the other hand, you could say that it depends a little bit on the context of the Public Records Act request. If we got a request for all communications involving employees' use of prescription medications while on the job that would impair their judgment, that might make this more subject to disclosure. If this were someone in a public safety position, that might also make it more related to the public's business. On balance, and I think reasonable people might possibly disagree, but on balance, I think one could probably redact the beginning parts of this as being insufficiently related to the public's business, but the statement from a commissioner of the Harbor District, understanding that there's been lots of new Public Records Act requests, interest in adopting a new public records policy, given the author, given the context, the purpose of the email, I think it's more likely than not that this portion of this email would be subject to disclosure under the Public Records Act. It's hard to know for sure since we don't know what the request says. The request specifies, I'd like all emails about ice cream. This may be a public record, but it's not responsive to that request, so the context becomes important as well. And then the second email is a much more complicated one.
Can we go back to the,
Yes.
I mean, I don't know if it's appropriate to go to this level of detail, but.
It's your meeting. I mean, this is I find this stuff fascinating. I could
Okay.
spend hours on this.
No, that's dangerous. So my question is this, one interpretation of that is that the commission is just simply asking for a meeting. So there's no, right, about the Public Records Act.
And is your implication being that therefore it would not be related to the
How would
public's
that
business?
be handled? Would it?
I would say an email from a commissioner to a staff member saying, I would like to meet with you to discuss the Public Records Act would most certainly be related to the public record, to the public's business under this analysis, this content-based analysis. The content of it relates to a meeting with an elected official. The purpose of the meeting, of the email, was to set up a meeting on a matter related to the public's business. The context was in an email from a commissioner to a staff member. That sounds to me like a public record.
Yep, okay.
Do you?
No, I completely agree.
Okay.
I think though that a key point here is that we're not, people who have a full-time job working for the district, and when you have to scrutinize every single email to this level, because the district hasn't had email addresses even for commissioners the entire time I've been on the board, and there's 5 years worth of email, it's an unrealistic burden to put on commissioners, and there's no way a commissioner is going to be able to have time to look through all of them and still do their job, their day job, to make a living and pay their mortgage. And they would need to have their own personal counsel review the email communications in order to make a determination as to whether or not something needed to be redacted or released or not released. And so this seems to be a problem with getting this going. And it somewhat unworkable for that reason, unless there's some mechanism to cover the cost of all the culling of email and redactions and what have you. I mean,
We've actually got a staff report on that very topic.
So that is an item we're going to be discussing. I agree with you wholeheartedly that this opinion leaves unanswered enormous questions and presents enormous difficulties for public agencies who want to be able to comply with the Act. It is, I mean, I don't want to, I really don't want to editorialize too much, but I mean, it's a really misguided opinion in a lot of respects. That doesn't mean that it's not the law, and it will take, as is often the case with Supreme Court decisions, litigation and follow-up lower court opinions to clarify what the law means. So I am not trying to disagree with any of the criticisms of the difficulties. A preview of a slide later, this court imagines a world in which it is easy to comply with the Public Records Act and to comply with its ruling. And this agency, as you've just indicated, is living proof of some of those difficulties that the court just doesn't, has no practical, makes no practical concessions to. I can't explain
it seems
that
like we're
to you.
going to need to put,
So-
we're going to need to factor that into our budget, that we're going to have money set aside to,
If I could suggest that maybe I think that's an important issue. It is on the agenda. I've got about 3 more slides, if you wouldn't mind
okay?
letting me shoot through them. Actually, I take it back. If you want, I can end the presentation now if you would prefer.
No, I would
Yeah.
like to hear the whole presentation.
Yeah, it's, here's the whole
Okay.
presentation.
So, next email. More tricky. Here's an email to the mayor of some unknown city on their personal account from a commissioner who has set up a campaign email account, and flash to the last sentence of this email, which says, "By the way, please respond to this Gmail email account so that I can keep my campaign separate from my work for the district." So here is an elected official trying to do the right thing by keeping campaign work separate from public's business, and has set up a campaign email account, is writing an email to the mayor, also on the mayor's private email account. Includes some personal, "It was great to see you at Charlie's graduation, I'm looking to see you at my conference, it's all about the election, I'd like to chat with you about endorsing my campaign." And then comes the interesting issue. In particular, since you know I'm planning on voting for item X at the next commission meeting later this month, and doing everything I can to make sure that item X happens. I know you're planning on gathering before the meeting to discuss the item with concerned members of the public, and think that it's great that you're supporting what the district is trying to do. So this seems, had this been written from a district's, a commissioner's official account to a mayor of another city, only discussing plans to vote for item X and how we can best make sure item X happens forward, that would be almost undisputedly a relating to the public business sufficiently to become a public record. The court completely fails to even acknowledge how to handle an issue regarding the attempts to separate out campaign emails, and this is something that a lot of us practitioners are pondering, and is one of the unknowns that I can only say is just an unknown. I think, in my view, if tonight you had to make a decision and like you're going to lock the door and I couldn't go home unless we made a decision, I would suggest perhaps redact everything except that says, "Since you know I'm planning on voting for item X at the next commission meeting later this month and doing everything I can to make sure that item X happens." That sentence seems to be hard to rationalize not disclosing that. But you can redact, and so this is an email where I think also some heavy redaction is in order. So some practical advice, in which I will close with. I think that keep remembering location doesn't matter. Court says that the agency has to make reasonable efforts to locate records even when they're out of its control. The court specifically said agency no one's going to be knocking on Debbie's door and confiscating her server to search through her personal email accounts. No intrusive searches. The agency can rely on the officials or the employees to assist it in responding to records requests. And there's 3 steps that I think that this agency now should do and maybe must do in order to comply with this rule. First is, the court is emphatically clear, is that the first step should be that when you get a request, you communicate it to the employee or the official in question. And we have done that already. I think maybe everybody in this room has received a notice saying, "We received the request, it seeks these records, please provide us with these records." So the agency is fulfilling what the Supreme Court says just by sending that notice. Then it says the agency may then reasonably rely on these employees to search their own personal files, accounts, and devices. What the court doesn't do is address, Commissioner Brennan, what you've just described, which is the court just imagines a world in which all officials and employees are going to conduct thorough searches of their personal accounts and assist in the response and provide the records easily without difficulty. They assume that everybody now has this obligation and will fulfill this obligation. The only advice the court stated is that in the instances when that employee or official has a record that they believe should not be disclosed because it's exempt from disclosure, on a case-by-case basis, almost on a record-by-record basis. Again, I'm just telling you what the court said. The court suggested that that employee or official that the agency could comply with the act by not providing that record if it has an affidavit from the official that provides a court a sufficient factual basis upon which to determine whether contested items were agency records or personal business. What is totally unknown.
Can you repeat that part again? I didn't catch that.
Sure. So under the Federal Freedom of Information Act and also under Washington state law, which the court endorsed and suggested that lower courts follow, there is a process where, I'll use me as an example, I get a request for all my records about district ice cream. This is the San Mateo County Ice Cream District. All my records about ice cream. And I give the general manager 20 emails about ice cream, but there's one, I submit an affidavit said there's an email I'm not submitting because although it mentions ice cream, it contains information having to do with my family's personal health, and it's a private record. It does not sufficiently relate. I've taken the training from the district's council. I understand that you look at the context, the content, and the purpose, and I maintain that this is not sufficiently related to the public's business, so that I'm not providing you with that. That's the kind of an affidavit, impractical as that may sound to all of us, that's the kind of affidavit that the court is imagining public agencies will now be able to obtain from their employees and officials. I can tell you...
For each email? Like say there was a series?
It's not clear.
Yeah.
It's just not clear. It's just not clear.
Yeah.
I can tell you that there are numbers of agencies who, and this agency it's an item that you'll talk about later, but there are people who are more trained than most of you in the room in making these kinds of judgment calls. So you could meet with your general manager or you could meet with your general counsel and say, here's an email, I've got my common sense, I trust my gut on these emails, these are not public. I trust my gut on these emails, these are public. Here's an email, I'm not sure, I need your help reviewing this, and just the same way that now, periodically, when the district gets a Public Records Act request, council's not automatically involved, but every now and then I get an email from general manager or staff saying, here's an email, we can't tell whether this is subject to an exemption, is this privileged, is this a deliberative process, is this responsive to the request, so every now and then I work with the general manager, sometimes on emails from some of you, but it's on the district server from your smharbor.com. So that kind of process could certainly happen. Ultimately, the district is responsible and needs to make a determination as to whether records are public or not. So what's really unknown, and this is my last slide, is how lower courts will respond to a scenario in which a public agency gets a Public Records Act request, does step one and says, Commissioner Lorenas, we have a request for your records. Commissioner Lorenas, for whatever reason, does not provide, I don't take it personally, does not provide records. Maybe there's an affidavit, maybe there's not. We don't know how specific that affidavit needs to be. Is it by each email? Is it by a series? What if it's General Manager McGraw who says, hey, I'm not providing you one email, go pound sand. It's unclear whether the district will be responsible for that behavior. It seems likely that it will be, but it will take a lower court to really set those rules, and so it'll take a lawsuit. So the solutions to avoid that risk is, number one, don't use personal accounts for official business. And it's been a number of years now that we've been providing that advice. And the flip side of that coin is only use your official account for official business. Don't use your official account for private business. On a going forward basis, if everyone does that, and you'll see that enshrined in the policy that we're recommending that you adopt. On a going forward basis, this will be easy because a Public Records Act request comes in for all emails on your personal account having to do with district business, and the answer will be, there are none. Because I don't do that. I have my official, it's less of a problem for us than for many agencies. There are dozens, maybe hundreds of small agencies that don't give elected officials official accounts. There are also multiple agencies where officials or employees sit by virtue of their position on another agency. You know, I'm the supervisor of the county of San Mateo and I sit on the California Coastal Commission, but I use my county email address to conduct Coastal Commission business. Maybe I don't get a Coastal Commission email at all. Maybe I'm on this some JPA that doesn't have, you know, there's just endless permutations and complications that the court just flat out did not acknowledge. So for us, all I can say is you have an account, I encourage you to use it for your official business. And as difficult as it may be, and I know there's going to be discussions on this issue coming up later in this meeting, the more we all, and this applies, I mean, there are no employees in the room besides the three of us, but the more we all cooperate with these requests and take the time, right now the district spends a lot of time responding to Public Records Act requests. It's now going to become incumbent on all of us to do that if the goal is to mitigate risk to the district. Because somewhere along the line there will be a test case to answer some of these unknown questions, and no one wants to be that test case.
Where
So-
are we at with getting next requests online so that the PRA requests that we've gotten so far are available to the public and we don't have to keep reproducing them?
Soon, we keep thinking that we're there, and then another little glitch comes up, the website, we're not quite there, so, we're incrementally getting closer and
So
closer.
some records have already been put on next request?
No.
In fact, Glenn was suggesting to get a tent to flesh it out, because it's huge to go back and
Okay,
have them.
So like, what does soon mean in terms of 3 months?
3 months at the most.
So that concludes my little, I don't know how I did on my timing estimate, but I hope that was useful and will help sort of keep that in your framework as you conduct the rest of your business of tonight's meeting. Happy to take any more questions if you
I
want.
have another question. So what
Do you want me to go back to a slide or just?
No. So in the case of PRA requests for an elected official's emails on blah, 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 they do the best that they can, send it in, and there's a dispute. What happens there? Whoever requested the Public Records Act request says, I don't believe this, so-and-so must have more emails.
Okay, so the best I can answer that question is, which is probably not a great answer because a lot of it is unknown, is that if there is an affidavit, the district would first try to use that to satisfy the requester. Ultimately, the requester would have to file suit to compel production, and the court will likely, and this is just what has happened in other Supreme Court, other lower court cases, the court compels disclosure in sort of what they call in-camera review in their chambers, and the court decides, was this a public record, was this not a public record, and makes a ruling.
But
If the commissioner says, I'm not giving you these records, or they are exempt, you don't get them, that is the fundamental unknown. Does the court have the authority under the Public Records Act to order hold an individual elected official in contempt because they're refusing to provide records? And would a judge use that authority? I don't know. My guess is that it will depend on the facts. There's an old truism that bad facts make bad law. And that if the facts involve an obvious attempt by an employee or an official to cover up what looks like obvious misconduct, the court's going to have less patience than facts where an agency has obviously behaved reasonably and reasonable people are trying to act reasonably to do the right thing. And so I think always my recommendation in responding to Public Records Act, and I believe the district does this pretty well, and there's a member of the public who I think, if asked, might share my view, is that we try to be pretty transparent about here's what we're doing. We got these many requests, we're asking for this, we're trying to do this, we're trying, we'll provide records on a rolling basis, we'll try to be reasonable, there's never, there's no effort to stonewall, there's no effort to try and shield, make up excuses for why not to give records, and you just gotta act reasonably, and, but the chips are gonna fall somewhere after this case, there's just too many unknowns. Is that
So
the best I can do?
are we talking now about this draft policy? Is that at
Well, I
this
think-
point in the agenda?
I think,
Yeah,
Question.
just let me ramble for a couple minutes.
on the
First of all, you guys,
presentation, right?
but,
On the presentation, yes.
yeah, what we're talking about here, but what you said about your cooperation with my requests, absolutely true. Before the previous regime, that was not the case. They played games all the time. But under Mr. Miller and Mr. Lazoff's always been upfront with me, and when there's been problems, he's just flat out told me, we're stuck or we've got a problem. So I've really appreciated the way it's been handled. The thing about I know you're going to talk in a little bit about paying for the legal fees of commissioners. That only makes sense because none of you knew this was coming. Right, I mean, I know some of you have been using your personal emails, but you didn't know that you were going to be exposed in this manner. And B, as Sabrina mentioned, it was a real battle just to get email addresses. They actually voted against doing it in this organization back in the bad old days. So, but I would say that a reasonable compromise is you got some PRA requests that you're gonna have to, you gotta go look for it. Let your attorney see what you think you should. Let him see. You guys pay for it, the district pays for it. But going in the future, when this has to stop, because it's a really simple, easy thing to stop. Just use your personal, or don't use the accounts that are provided by your districts. If that means that, and this would tie into your third item tonight, using district-provided equipment, that's what it means. But the thousands of dollars you would spend to resolve this problem, it ain't gonna be nothing compared to the thousands of dollars you're gonna spend if you don't, for what you're gonna pay to have her emails and his emails and her emails and his emails gone through by him. Because that's really what you're owed, I think, in my opinion, at this time, since the rule changed since you got here, that the district should back you up on this and look at your emails and make sure you're not disclosing information that you shouldn't be disclosing. It's not up to you to make that call. If you had done the emails the way you should have, then he'd be making the call. But I don't see why there's any problem with you handing the emails that you think are responsive to these requests to him and asking him, vet them. I don't get why that would be a problem, but in the future, it just shouldn't happen. There's just no excuse for it. It's a pretty simple thing. Now, the one question I had, and I'll go real quick on it, is you didn't cover people like me. We can see that the cartel is after me and after a lot of people, and he wants to see communications between me and the commissioner. And there's another request in here that the commissioner has put, that if you take it to the extreme, gonna include me. And I'm just a constituent. I'm just Joe Blow six-pack sitting out there, and I write my congressman or my representative, and I've got an issue, and sometimes I might just say hi, or I might send a link to a story, or maybe I'll say something, but I have no stake in any contract. I have no influence with anybody in this county. So in that situation, am I protected or not?
Happy to answer
Go
if
ahead.
you want to. So the definition of a public record
Mhm.
is it must be prepared, retained, used, or maintained by the agency. And the court has now decided that agency officials and employees' records are maintained by the agency even when they're located on their personal servers. But there is no possible basis under this opinion or any other opinion to assert that a member of the public's emails are public records. The email that you send to General Manager McGraw becomes a public record only by virtue of it being
Right.
on his email.
But if I sent it to Tom at his personal email,
Now that's a district public record because he has it, not because you have it. You will never, ever,
well, they wouldn't come to me to make
They
me
will-
search mine, I understand
no
that.
one will ever ask you for your emails.
I get that, I mean, but I'm just saying is,
But
so
you-
you're saying any public person who sends an email to their any representative complaining about something, or they've exposed themselves to being outed and to being called out.
Well, I guess I would say presumably if you send an email to your elected official, you're not expecting that to be a private email. If that happens to be your friend and you send an email to an elected official saying, hey friend, wanna meet for a beer next Thursday,
Good.
that's the kind of thing we were talking about, is that elected official will have to now make the determination that that's a personal email, not a public email, because it doesn't sufficiently relate to the
I'm
public.
guessing just that a sophisticated person, like, who's played the game a little bit, I get why everything is the way you're saying it is. And I'm not saying there's anything wrong with that either. What I'm saying is that the average person who maybe talks to an elected official 10 times in their whole lifetime, and maybe is complaining about something that he doesn't want his neighbors to know he's complaining about. Because in this town, we've seen some people actually have had actions taken against them because they complained about the lights or CDP not being handled right or something like that. You can see why it's somewhere, to me, it's getting close to the line where if you had a tip line, for example, somebody called you in and said, there's somebody doing something bad. You obviously wouldn't disclose that person's name because you've promised them through the tip line. Usually the standard thing is that you don't disclose that kind of thing. And it's probably a bad contrived example that I'm coming up with here, but
No, that's a great example. I think a voicemail message left on a tip line is a public record. It is exempt from disclosure because it falls into the category of exemptions to disclosure. But
You
the
would
starting
actually-
place is that it is a public record.
in my experiences, I've actually had that happen. I actually got a voicemail from the Bay Area Air Quality Management District from a tip line, and it was obvious who made the tip. And it was like a shock. And I didn't expect that, and so I'm just wondering, you can see that maybe there has to be some disclosure to the public that if you ask, your name is now a public record. If you send an email to a public official, no matter what, you're not gonna be protected.
We can probably move on, because
Yeah.
but this conversation could last for quite a while.
No, I appreciate you guys talking.
But I'm just actually, on our website, for example, if somebody goes to our website looking for how to contact a commissioner, right there is the disclaimer that the member of the public will read, saying that if you communicate with this elected official, it will be a public record. And
There you go.
so
You guys covered it then.
it's right there on the website, yeah.
Do you have any idea exactly when commissioners did not have harbor email in any way, shape, or form?
I wrote that question down to see if I can find out the answer. I don't
I
know
can
the
tell you
answer.
when I joined, everybody had email addresses, so it's been at least that long.
When did you join?
July 1, 2014.
It happened just a few months prior.
It was
to
right
coming.
before that, and the reason it happened was because I fought tooth and nail to get Harbor Commission email addresses, and it was an uphill battle, and it was very challenging.
It was really strange. They denied it, and then the next week, you all got them. They voted against it, and then suddenly you got them.
So, I asked for them starting in 2012, well, actually, it was starting in 2011 before I even got on the board, and it took years before it finally happened. the other thing about that is, we have a problem with our email. It doesn't work on my machine and has crashed it several times to the point where it's prevented me from actually doing my job. And for that reason, I can't use the district's email system. And I called the IT, because we have the district IT contact, had numerous conversations with them. They even did screen sharing, all kinds of work to try to make it work. And at the end of it, and I asked him to include this in the report, it was determined that the best thing that we could possibly do, because I have to use my personal equipment because we don't have district issued equipment, the best thing that we could come up with was that we needed to remove the district email from my machines. And as soon as we did that, all of the problems went away. I no longer had my machine crashing. I no longer had thousands of messages being flooded to my inbox and completely wiping me out. And it's been a disaster. Every single time I've tried to get the district's email system working on my devices, and I have many devices and I use all of them for email, it's blown up my business. And so something's got to be done about that.
That's also another item on the agenda this evening.
Yeah, it's incredibly frustrating. So I'm in this predicament where if I want to email anyone at the district, including commissioners and staff, I use personal email and I have to do a CC, a copy of my district email address. I try to always remember to do that to ensure that it gets into the system. Now, it should be in the system because the person I'm emailing is in the system, but I want to make sure that it's, make double sure that it's in the system. So I try to always remember to copy myself with my district email address. But this is a ridiculous situation, and it needs to stop. There's got to that gets back to the big problem. Okay, we finally overcame the problem of not having district issued email addresses, so we were able to finally move the ball slightly forward. But then my struggle to get the district to issue district equipment or give the commissioners some sort of a stipend so that they could buy their own equipment that's specific to the district, however it needs to work, I don't really care, was completely ignored for years. For years, I have emailed the general manager, I've emailed our council, I've talked about this publicly over and over again, how we need to get district issued equipment, and it hasn't happened until maybe tonight, I don't know. But I think that that's really the root of the problem. And what I would like is to have a district-issued computer so that all of my district business is on that machine, and if anybody needs anything, I can just hand over the machine to IT, and they can get whatever they need, and I'm done with it. That way it's supported by the district IT department. And there's no other reasonable way to do this, because I can't haul in the machines that I use to run my business to the district's IT department. That makes no sense, and then I'm out of business. So, this is just an untenable situation. So the sooner we can fix this problem and get district issued equipment, the better. But as far as this policy goes, there's so many problems with this policy, I don't even know where to start. So are we talking about the policy yet? or-
Yeah.
We can be, so is
Well,
the
let's
policy.
go ahead and start with our staff report
Right,
and
right.
see if we can answer some of these questions in the normal course of business.
Thank you, President Mateo. So, PRA policy. The district has been abiding by state law. Because in February of 2016, this commission rescinded a previous Public Records Act policy that had been adopted at the beginning of 2015. So we've continued to comply with the Public Records Act, but the District Council and I felt that there was certainly a need for a clear policy, and additionally, in order to achieve the goal established by this commission to gain the CSDA's certificate of transparency, we're required to have a Public Records Act policy. Public Records Act policy could be as simple as the district complies with state law. But especially given in light of the Supreme Court decision and the presentation that General Counsel made immediately prior to this, we felt it better to have something a little more comprehensive. So we clearly state in the policy the purpose of the policy, which is to comply with the California Public Records Act, and that consistent with that, in the policy it says that the public records are available on request. Every member of the public has a right to inspect any public record except those exempted from disclosure, as General Counsel was discussing earlier. The policy clearly states that the district is not required to create a record, and it's not required to respond to prospective requests in the future. As soon as you get this document, would you send it to me? I'm making a California Public Records Act request for all emails going forward on this topic. So the Public Records Act does not require that those documents be supplied. So the policy states that if a requested record is a public record and available for inspection, determination as to whether it's to be disclosed be made by the general manager, but in consultation with district counsel as necessary. We'll respond to every Public Record Act Public Record Act request in accordance with the law. We may choose to try to seek a little more clarifying information. If the record doesn't exist, if it's exempt from disclosure, we'll tell the requester. So to facilitate that, and as General Counsel went through in the presentation, all district employees and officials should adhere to the following requirements. To the greatest extent possible, emails that relate to district business should be sent to and from employees and officials at smharbor.com email accounts. We shouldn't conduct any public business on our personal accounts. And if, for example, in the case especially of an elected official, where somebody sends an email to a personal account, the recommendation in the policy is that you promptly forward that request, that email, to your official account, and then reply from that official account. Conducting business via text messaging is discouraged. Certain district employees are provided with a district phone. We may extend that out to elected officials later on this evening. So for those who have the district phones, if there is business or communications to be conducted by text, use that phone, not the personal phone. Under the Supreme Court, communications that relate to district business may be public records even if they're on an employee's or official's private device or personal account. This is something that, again, General Counsel Miller just went through. If requested for, a request is made for a record on a personal account, the employer or official will make a reasonable effort and will provide those records to the general manager in a timely fashion. The general manager or his designee is responsible for complying with that, so the records should come into the office then to be distributed out to the requester. Determining, again, as General Counsel talked about, what efforts are reasonable and what records are responsive will always depend on the specific facts and circumstances. And employees and officials could seek guidance from the general manager or counsel when it's difficult to determine the status of any particular record. And then the policy concludes by saying that the general manager will develop the procedures and amend those procedures from time to time as may be necessary, consistent with this policy and to ensure compliance with the Act. So the policy, I think, is fairly straightforward. We will abide by the Public Records Act, and we will comply with state law. So most of the items in this policy are guidance items to the greatest extent possible. Text messaging is discouraged. So I think that the policy is more explanatory and providing advice and counsel on how to move forward to make sure that we don't have issues with personal accounts. But it recognizes the complexities and the unknowns that your general counsel talked about earlier. So with that, I'd be happy to answer any questions.
I have several questions. First of all, I think, I'm not trying to be recalcitrant, and I think it's important to have this policy. However, I've only had limited time to digest it, and also there was no time for input from any of the commissioners towards this. Now, I don't know if, since I'm new to the commission, I don't know if it's a standard of organizations like this to just have someone write a policy and then we just look at it and say we like it, or is it in general?
You can amend it tonight. You can provide direction for us to amend for adoption at a later meeting.
Right.
But ideally, we try to write a policy that meets the goal.
Sure.
And make it as clean and as clear as possible, and give you something to chew on, rather than just say, come to a commission with a
That's
blank
great.
sheet of paper.
That
and
was my
say,
question.
Let's write a PRA policy.
Okay,
This certainly shortcuts that process.
Okay.
So feel free to recommend changes to
The
the
reason I
policy.
was concerned is because the second page starts with the resolution, and so
Yeah.
it seemed to me we were gonna vote on this, and I for one would like to sit and actually read this and give it some careful thought before we implement something like this.
I
Would
have,
that be a motion to table this till the next meeting, perhaps?
I think the discussions is really useful. I'd like to hear what the other commissioners have to say, and I may have some more questions for you
Yeah.
and for
Yeah.
Mr. Miller, because I think it's I like the idea of having policies. In fact, I've been asking for the
Yep.
general policies of
Yep.
the district, so I know what our rules are. And, a policy that's been well thought out and vetted by everyone I believe, will be a much better policy in the long run, even if it does take another month to get at it, since it takes a while to do these things.
Well, I think that if you want more time to
Mhm.
review these, you should have it, and I mean, I would make a motion to table it to the next meeting.
But I'd like a
Whenever-
discussion.
Yeah, we discuss it at the next meeting too, but if you haven't had it, I don't care. I mean, I just, meaning, if you wanna discuss it now, that's fine, but if you're saying you haven't had a chance to review this, I haven't either, so I'd like
Right.
to review it as well.
But this is an opportunity to have a discussion about it.
Yeah, that's fine. I don't care.
With council here, we can ask questions.
Well, he'll be at the next meeting anyway.
I think
believe
developing.
Commissioner Brennan has some input on this right now.
Thank you,
Yeah.
appreciate it. So I think crafting policy is something that the board is supposed to do, and this provides us with an opportunity to consider a draft and to talk and discuss and to try to come up with a policy, and maybe we do that now or maybe we do that later. But I think to not work on it when we drove all the way over here to have this special
Yeah,
meeting
bad idea.
would be,
Yeah, that's fine.
we'd be remiss in not making an effort to try to weigh in on this and give input, especially if we think it needs more work. And I definitely think that it needs more work. So I'd like to talk about some of the things that jump out for me. Well, first of all, I wish that we had started working on this sooner, because I know let's see how this worked. In 2016, was it 2016 we had a policy? Or was it 2015?
You adopted a policy in early 15. and
In early
rescinded-
15.
And rescinded it in early 16.
And why did
Yes,
staff
yeah.
want us to rescind it?
It was rescinded because it was more restrictive than the California Public Records Act, and staff was not able to meet the requirements of the policy.
Okay.
thereby breaking the law.
Well,
So-
by
Pretty
not being,
much.
no, not being, we were not breaking the law, we were
Well-
just not compliant with our own policy.
Oh, okay.
Right, and so, and you're absolutely right, we did start and wanted, in fact, at one point, to bring to this board a policy in February, and we were working on it, we missed the February deadline, and then at the beginning of the March, was the Supreme Court decision, and
Is
we
the old policy-
derailed,
Is the 2016 policy in here? Did I see, is that included?
No, I didn't,
So I
actually. I
think-
emailed it out.
I think that we need to make sure that we get the full, when we get staff report, we need to make sure that we get the full, complete picture. And that would mean that the previous policy that we rescinded should be included, because I think
Right.
it's an important,
okay.
it's important to look at that and to see where we were, and then to understand what specifically about it was an issue, because I don't, I kind of remember what happened, but, we had one, then we didn't have one for like a year, right?
Right, and we still don't have a PRA policy.
I know we don't have a PRA policy, but what I'm saying is, we knew this court decision was coming. And yes, we've been talking about it at CSDA meetings for over a year, so clearly,
Yeah.
all the lawyers that work with CSDA knew it was coming. And so, it would have been helpful.
They didn't know, I don't know,
No.
did they discuss the actual ruling that
It's,
predicted?
It was
But-
predicted.
Yeah.
Okay,
Yeah, if
they
you
did.
don't mind.
Okay.
if you
Well, I
don't-
just had
if
a
you-
question on your comment, because I didn't know.
If you don't mind it, just, you could ask that later. So, I just wish that we had started this process a little bit sooner, because I think right now we're in a predicament where we are faced with an escalating number of PRA requests for personal communications, and so now we're scrambling. And so I'm a little disappointed that we didn't start this process sooner. So I think it's good that we're here. I'm glad we're meeting about this. And I definitely see the urgency in getting on it. But I also think that we want to make sure that we craft good policy. And to do that, it needs to be really well thought out. So that's kind of where I'm at with it right now. Now, regarding the policy that's in front of us, or the proposed draft policy, some of the things that concern me about that, and I'm gonna bring them up now so that the other commissioners maybe you have or haven't thought about these things, but, here it says, I'm just gonna go through the stuff I highlighted.
Which page are you on?
I'm on page 1 of 2. Determination as to whether a requested record is a public record and available for inspection or copying, as well as decisions to withhold a record will be made by the general manager in consultation with district council as necessary. Well, that is in conflict with what we just learned in our training, because what we learned in our training is that not only will council make decisions and the general manager make decisions about things that are specific to email that's in the Harbor District system, but also board members and staff members and consultants and maybe general contractors working for the district, or plumbers, or literally anyone that's involved with the district at all will need to make determinations according to the training on what to do about Public Records Act requests. So I think that this is too specific here, so I'm giving you that input because it doesn't include all the rest of everybody else that we just talked about in the training. So there's gotta be more meat here on that to make it clear that all of these different people are involved with this process now. It's not simply the general manager and our general counsel, it's determinations made by individuals as to what they're going to turn in to.
But the contractor who emails me about something doesn't have to do anything.
Yeah, they might, because if, say a person put in a PRA request for a contractor that worked for the district, and they wanted their personal communications because they thought they were communicating with somebody maybe on the board, and they were working some kind of like backroom deal, and somebody was getting bribes, or who knows. You might need to ask for their communications in their text messages or their whatever. So then
I think general counsel can answer this. I think I know the answer, but
so I'm just saying that
Yeah.
we need to include that
Right.
they're,
do you wanna?
I wanna
Right.
keep going. I don't wanna keep getting interrupted. So if I could just keep going, then maybe you could come back to that.
Okay.
Otherwise, we're never gonna get there. Thank you. So then on page 2 of 2, it says here, ordinarily no public business should be conducted on personal email accounts. Well, as I highlighted earlier, that's not possible because there's so many problems with the district's email that my inbox gets flooded with thousands of messages every time I try to use it. So ordinarily, there's never been a time ordinarily where the district's email has worked for me. That's been my experience. And so I've tried it a couple of times and it's just not possible. So we need to make sure that we have a functional system, and that needs to be addressed in here somehow. The insurance that there'll be some sort of functional system. And right now that's not the case. And I'm not blaming our tech support for it. I don't know what the problem is. I don't know if it's the software we're using, why the spam thing keeps happening. I don't really understand what the problem is, but it needs to get fixed. So next section, conducting district business via text messages is discouraged. Well, I get text messages from the general manager, what is this all about? So everybody uses text messages now to communicate. I don't think that's really a reasonable thing to put in here because it's like pretending like we're not in the 21st century, and the reality is that people use text message to communicate. So this I'm not comfortable with because I don't think it reflects today's communication methods, and if we put things in here that are not useful or reasonable, it's not going to work. People are going to continue to use text message. That we can just count on that happening. And then there's nothing in here about social media chat. People are talking via social media. They're talking to each other on Twitter, they're talking to each other on Facebook, and all these other types of social media, Instagram, whatever. Not covered at all. We need a whole section on social media communication, so that's been overlooked. And then it says here, for those district employees or officials who are provided with the district telephone, text messages that relate to district business should be sent to and from phone numbers associated with that phone and not from personal phone numbers or other personal text messaging services. This is a very confusing sentence.
Yes.
And this sentence seriously needs to be rewritten because I don't think anybody is going to be able to figure out what that means. So I think I sort of get the gist of it, but I think too much is trying to be communicated in this one sentence, and it's extremely long, and it really doesn't make any sense at all. So I get the sort of the spirit of it, but it's poorly crafted sentence, and it's just going to lead to a lot of confusion. So if you're going to start to talk about text messaging services, I'd have a whole section on that on its own. And as far as the phone business about calls, with people who have district issued phones, we probably need a whole section on district issued phones as well. And to try to blend this all together in one sentence, it's just not well thought out. Then we get to this section here about, this is the third paragraph. The employees or official will make reasonable efforts to locate responsive records and will provide such records to the general manager or designee in a timely fashion. Well, that's pretty vague. What does that mean, in a timely fashion? Because I was told about Commissioner Virginia Chang Corrali put in a PRA request for my personal communications, and I believe Commissioner Lorenas' personal communications. How many months ago was that? 3 months ago, okay? And we're just having this meeting now, and when you put in that request, I asked to have this meeting immediately. And it took us 3 months to have this meeting. And we're not really there yet, because this thing needs to be recrafted. So I'm just concerned that we're not really doing things in a timely fashion, and that we need to think about what timely fashion means, and there needs to be more clarity about what that means. And I think we're missing timing parameters in here, which I do think was in our previous policy that got rescinded. I think there was some specificity about what the timely fashion meant, and I think we need to bring back some specifics about how fast we have to respond to things so that it's clear to people, especially since we may be asking staff members to respond to requests for personal communications. And so the employees, whether they're commissioners or staff or contractors, anybody working related to the district, they're going to need to know, how quickly they need to respond to all these things, and it's going to need to be specified in this policy. It's going to need to be very, very clear to everybody what is expected so that we can all meet the terms. And there should be reason, it should be explained why we have the timing deadlines that we have, and, we need to meet the Public Records Act, and, how do we do that? So, all those things need to be sorted out, and I think that would need to have its own section as well, specific to timing. So, moving on, let's see, what does it say next here? Determining what efforts are reasonable and what records are responsive will depend on the specific facts and circumstances, but always in light of the Public Records Act. Okay, that's pretty vague. I think we need to kind of get into the weeds of what we learned in the training. There needs to be more specifics here so that we know what we're talking about. Then it says employees and officials will seek guidance from the general manager or district council when it is difficult to determine whether a particular record is a public record. Well, I can tell you that if I'm looking at a personal email communication, I'm not going to share that with district council or the general manager because it's personal communication. So this doesn't make any sense. If if it's personal, I'm not going to share it. So we need to explain what that means, and if there's personal communications that an employee has concerns about, they should be able to go to their personal counsel, because you wouldn't want to disclose personal information to people that are not advocating for you, because it's your personal stuff, and so you need your personal attorney. So that needs to be clear. We can't be asking our staff to hand over their personal communications to our management. That would not, I think we could get into all kinds of legal trouble for doing that, and it just wouldn't serve their best interests. So our staff would need to be able to make sure that their personal counsel thought it was something they should or shouldn't release, and if something needed to be redacted, their personal counsel would need to advise them on what would need to be redacted and what wouldn't, because the staff isn't, I don't care if they sit through this 10-minute training or not, they're still not going to be able to make those types of determinations because they're not trained attorneys. That's why we have our counsel reviewing emails before we release them in public records requests. We do that because a trained attorney needs to make a determination as to what's in the district's best interest and whether it's something that should be released or not. Well, the same thing goes for a member or a staff member or a commissioner. They would need to have their personal attorney review their personal communications to make sure it was in the best interest to disclose information, that might have some, it might be about some real estate deal they were doing, to buy a new house or something. These are things that you wouldn't want to, that could be sensitive, and you wouldn't want to have the wrong thing fall in, and especially if you're looking through thousands of records. How is a staff member or commissioner supposed to process that much information? Say you have 50,000 emails and you've got to do a search. How are you supposed to process that much information and make sure that you got everything redacted that should be redacted? Well, if it's a board communication and it's in the system, then hopefully we have processes in place to do that. But if it's a staff member that is looking through personal emails or text messages or Facebook chat or whatever, you know, and you can't tell staff that they can't use things like WhatsApp because everybody's using WhatsApp. We can't tell people that they can't use WhatsApp. I'm sorry, but we can't. And so they're going to keep using it. So who's going to decide whether they put something on there that had something to do with the district or not? You know, I mean, who's going to call all that? We really got to sort this out. So next, it says here, district's compliance will in part depend on the cooperation of its employees and officials. Well, what does that mean? I mean, does cooperation mean that we should turn over our personal communications to the district's general manager and the district's attorney to review? Because that would seem to be inappropriate. And I don't even think that would be considered legal. You know, so I think we have a lot of legal questions here. And I definitely think that if we're gonna be turning over personal stuff, we gotta have personal counsel reviewing it. And there's just no way to do it otherwise that I can come up with that would protect the individual. And I think we have to protect the individual. And that's really important. So we've got the problems with the tech support. We've got, what if you had 50,000 emails and there was a problem with your personal email server? The company that you work with, say it's Yahoo or maybe it's Gmail or whoever, and they do some kind of reconfiguration and suddenly, boom, all your email is lost, okay? Everything's wiped out. And you're like, oh my God, there was all kinds of email to do with the district in there, you know, because maybe you don't have a district email address or whatever. What is one to do? So then you're going to need to do some sort of like forensic de-archiving project, and you may have to bring in some outside IT expert, you know, to because you call Yahoo and you say, you guys lost all my email, it's all gone, and they say, yeah, we looked and we don't have it, you know, it's gone. Well, you know, it's still on the internet somewhere. I mean, everything lives forever. We could go down to, what's that place, the museum where they archive all the data on the internet in the world? It's in San Francisco. So would we go there and would we ask them to look for it? I mean, we know it still exists somewhere. What's that museum called? I forget. I have a friend that works there. You know, would we go knock on their door and say, we need that email because there's a PRA request and there could be some district email in those 50,000 emails that Yahoo can't seem to find now, and there was some catastrophe with the server and what have you. Stuff happens. So we know it's living out there somewhere. Nothing disappears forever on, you know, as long as it's digital. You know, there's just a lot of issues here, and I think this policy, this 2-pager isn't going to cut it. So, you know, I don't know what we're going to do about this, but it seems to me that it ought to be a team effort, and the other law firms that are working with special districts and through the Special Districts Association need to get together. I don't think we should be working in a silo. I think that these law firms have a vested interest because they are all well paid by these special districts. They need to get it together, and they need to figure out what a really smart policy would look like to address the new laws. And, you know, we need to see comprehensive. We need to see something vetted through the Special District Association. We need something that is a lot more bulletproof than this thing. So those are just my preliminary thoughts, and I only read this today, so it's just kind of off the cuff.
Commissioner Corrali.
So, I wanted to,
I need to make a comment.
do you, in response
No.
to Commissioner Brennan?
No, go ahead.
Okay, so, Steve, thanks for putting this together. I find it fascinating that we had such a specific policy that was rescinded at the beginning of 2015 under a former board that we're actually now in compliance with California state PRA laws. So I don't want us to be out of compliance with our own policies by making something, more general, more specific again. So, this is, I agree that there are some questions here, but I think it's pretty clear that if you want to do the right thing and if you want to help comply with the PRA laws of California, you would do so. So I know that I've received at least 2 or 3 PRA requests personally from Commissioner Brennan's supporters for my personal emails and my personal correspondence, which I have turned over. So, because I wanted to help comply with that. And so whether or not I've requested this 3 months ago or tomorrow or yesterday is irrelevant. The point is, if you want to help with that, then you can, and you should. So I understand what you're saying here, although I do, I think maybe what needs to happen is that something that references that this is part of the state law, that, the language, I don't know, is the language from the actual state law? I don't know.
Much of it is,
Yeah, so
but much of it is not.
okay, so I don't know which part of this is, the state law stuff, language, or which one is the district's language. I haven't read the actual law. So I can understand why there are some questions. But I think that it's about your ethics and it's about your values of wanting to help. The one thing that I do think that we need to keep in mind, and this is gonna get to actually the reimbursement costs for legal, reimbursement for commissioner costs for personal legal representation. I think that taxpayers, we have a fiduciary duty to taxpayers to make sure that the public agency, which is the Harbor Commission, is the #1 priority. Not necessarily the individual commissioners, because if they go and break the law, and I'm not saying anyone here has, that is not the taxpayer's responsibility. Taxpayer's responsibility is to make sure that a public agency is functioning well. So I don't believe that, I know that we have our legal counsel going through, as the general manager has stated, going through our PRA requests, to make sure that we're complying, but also kind of seeing what should be put out there and what shouldn't be. So I'm okay with that if commissioners want to turn over stuff to our general counsel who was hired by the commission, but I am not comfortable, and so the taxpayers understand that their money's going to that. But taxpayers should not be on the hook for reimbursements for personal attorneys, because that's a personal decision. Because that commissioner can choose to either give his or her documents to the general counsel of the Harbor District or turn it over. We pay for, and the taxpayers pay for, our general counsel currently on, for the commission. I do not think it's appropriate for taxpayers to pay for personal.
Yeah.
I know,
That's the next
I know,
item.
but it was discussed, but my point is that this is a philosophy to me, is that the taxpayers, are benefiting from the public agency, and so to me, the public agency has to be protected.
Mr. Miller?
So I wanted just to clarify one thing in the original slideshow that maybe it's not a clarification, maybe it's a correction. I just either wasn't clear or didn't say it correctly. So the Public Records Act applies to employees and officials. The only way that, and I mention this because Commissioner Brennan, you talked about getting the records from contractors. I don't think it's correct, and if I made that, it seemed that way, I apologize. I don't think suddenly all of our contractors are suddenly subject to the Public Records Act. They would have to be serving in a capacity equivalent to an employee or an official. So for instance, you have chosen to hire outside counsel, but I could be your in-house general counsel with a smiller@smharbor.com email. You have for a number of years, you had your director of administration was a consultant, but he was serving in the capacity of an official. But I don't believe that the Public Records Act entitles the public to seek the records of you hire a plumber and they suddenly magically become a public agency official. So if it seemed that way from my presentation, I take that back.
Well, is there, can you show us some law on that so we understand the distinctions? Because I think that wasn't clear in the presentation, and so I think we need to see the law so we understand exactly where the cutoff is. Is it they work there 10 hours a week, or they work there 30 hours? You know what I mean? At what point? So I think that's got to be clear in the policy.
I don't think that I can provide you with a black letter cutoff. There are a number of different filters through which you could view this. So for instance, our conflict of interest policy requires consultants under certain circumstances when they're making decisions for the agency and acting in the capacity of officials, they have to file Form 700s. That's one way you could measure whether someone is the kind of a public official whose communications are public. There's people who are hired as like seconded staff, like Mr. Lazoff, or there are, we outsource our HR function to a particular entity. So I don't think that there is a simple one law that says the following people are public officials subject to the Public Records Act. I don't think it's ever going to be possible to do
okay,
that.
so
There's going to be, and if I could just say one more quick thing, because it's somewhat related. As you consider drafting and redrafting this policy, I think it is worth keeping in mind that we're in an area where there are a lot of unknowns, and specificity is not necessarily, and again, this is your policy, so you'll have to decide this, but specificity has its disadvantages in a world of unknowns, and to draft aspirational policy goals within which there's room to maneuver as more facts come up may be a strategic way to draft a policy that actually can be implemented without a decision tree that takes 7 pages to get you from point A to point Z. So I think most agencies that I'm aware of are considering policies that are more broad in general, and many such policies are. And they're living documents, so you'll get another case that come down that will say something that will make you have to come back and revise your policy. But the more specific you are, I've said my piece. That's one thing for you to consider as you redraft this policy.
I have a couple questions.
I just see some of the requests and discussions that we've had here. The PRA requests are topic specific, and the one thing that we've encountered in the past with Mr. Lazoff is when we get a broad request, he's gone back to the requesters to try and filter it down to something more nominal. So it isn't a question of taking every single thing off of our personal servers, it's topic specific. And I think that's something that we shouldn't lose sight of.
Right.
I don't see how something not related to the topic at all is going to be brought into this. And the other thing is, we're all free to talk to our own counsel, but we've got that coming up on another
Item.
issue.
I just
Commissioner
had
Brennan.
Thank you. I just had a couple of questions, really based on what Stephen just said. So I agree that we should be working on a policy, not a procedure. So I don't want anyone to be confused. I'm not suggesting that we need to develop a procedure in place of a policy. I do think it needs to be broad enough to be a real policy, not a procedure. But this policy doesn't cover a lot of things that need to be covered, and it's also very confusing. So it's not a well-crafted policy at this time. After we get a well-crafted policy, then we're probably going to need a procedure to go with it, or some guidelines or something. But I would imagine that being a completely separate document that staff would want to tweak as needed.
Yeah.
And that brings me to the point of the last sentence here in this thing where it says the general manager is also authorized to develop procedures and to amend those procedures from time to time as may be necessary consistent with this policy and to ensure compliance with the act. I think it should be a little clearer here because it's confusing. The sentence is a little confusing. I think it needs to be clearer that a procedure document would be like a guideline, which would be a separate document, because it gives the impression that the general manager is gonna have the authority to go in and change this policy. And so I think
Okay.
that could be clarified, so that it's like, yes, and we wanna do all this, and we're gonna have a guideline that will change over time to help us implement, you know? So I think that would be helpful. And then the other thing is, in order to really do this well, I think we need to reach out to the other agencies, and it doesn't sound like that's happened yet. And we need to get examples of other policies. So it would be really helpful if the next packet included examples of policies from other agencies or drafts that they're working on. And I think at this point, everybody's in the same boat. So everybody's working on this, and it would be really great if we could just I'd like to see 6 examples from other agencies that are like a similar size and look at how they're thinking about dealing with this, because there's cities that are affected, there's special districts, there's county boards of supervisors, it's all government in California, and so certainly there's lots to work with here, and we don't have to be coming up with something in a silo. I think we really need to broaden our approach, and I think we're gonna get ideas from some of those other drafts that we might not have thought of, so that we can come up with something a little bit more comprehensive. And I always think it's a good idea to look at other policy and borrow the good stuff, you know. So it seems like that's kind of where we're at with this at this time.
If there's no more discussion, I'd like to hear a motion to table this item and bring it back with some of these improvements.
So moved.
Second?
I'll second.
Do you want a voice vote on that?
Yes, please.
Or roll call.
Roll call.
Roll call.
President Matoush,
Yes.
Commissioner Lorenz,
Yes.
Commissioner Chancarelli,
Aye.
Commissioner Brennan.
Aye.
Moving on to item C, reimbursement of commissioner legal costs related to PRA compliance. Staff report, please.
Yeah, thank you, President Matoush. This staff report was generated partly in response to some of the issues certainly raised by the Supreme Court decision, and also specifically, as mentioned in the staff report, by a request from Commissioner Brennan. And in reviewing this, it's clear to say that the Harbors and Navigation Code, our governing enabling legislation, authorizes the district to reimburse commissioners for actual and necessary expenses incurred as part of their official duties. It's unclear whether personal attorney's fees are, in complying with the Public Records Act request, is necessary expense, and or whether such an expense is already anticipated or provided for in the Harbors and Navigation Code limitations on salary. So we have a commissioner expense reimbursement policy, and in looking through and crafting this staff report, I determined that there were 3 possible outcomes for this, should the commission wish to move forward. So the existing reimbursement policy, 4.2.4, which is included in the staff report, largely geared towards travel, training, and conference expenditures. But it does recognize that there may be other expenditures not specifically and explicitly mentioned in the policy, and so it allows for the reimbursement with prior approval of the full board at a public meeting before the expense is incurred. So this may slow down the process of responding to PRA requests that impact personal accounts should a commissioner wish to seek such reimbursement and needs to wait for prior approval from the board. However, when a request for records under the Public Records Act is made to the district is responsible for responding to the request. So staff believes that the professional services used in support of fulfillment of the request should be under the direction of the district, i.e. district council can assist the commissioner and to allow for district funds to pay for an attorney who may not be versed in the PRA to determine for the district which records may be responsive to a request could be problematic and is not advised. Recognizing again that it is the district that is charged with responding to the request for the public records. So the commission could revise the reimbursement policy if there was a choice to cover legal fees or reimburse legal fees under the existing policy, which would require prior approval of the board prior to the incurring of the expense. Regardless of how the board wishes to do this, should the decision of the board be made to allow for the reimbursement of commissioners' legal fees, the invoice supporting that reimbursement request must accompany the request. And so a commissioner may wish to think about that implication as well. So option one would be to include any reimbursement of legal fees in any proposed Public Records Act compliance policy. Staff believes, however, the more appropriate place should this option be elected is to identify these legal fees in the reimbursement policy 4.2.4, which could very specifically address the reimbursement of legal fees in compliance with the Public Records Act. A cap or a limit could be placed on that. And certainly, as General Counsel has made clear, so much of this is uncertain that we may get to the point where any district policy that we adopt in regards to this could be invalidated by future case law. And then the third option, should the commission wish to allow for the reimbursement of legal fees, again, is to abide by the existing district policy. If this commission does not wish to allow for the reimbursement of personal legal fees, any commissioner may of course request the assistance of district counsel, which is in fact the recommended course. So we did not draft a policy on this. We're seeking guidance, and I'd be happy to answer any questions, take guidance from the commission at this point.
I have comments. I'm not sure they qualify
Okay,
in the
I'm
land
happy
of
to answer
guidance.
questions, take comments, get guidance, whichever way you want to do it.
And when it's appropriate, I think there is one legal gloss that may be helpful for you to hear in addition to that staff
So why
report. So-
don't we hear that first?
Sure. I think there are two unknowns that I cannot hear and tell you what the answer is, except to tell you that it is unknown and that there are some risks and that you should adopt whatever policy you decide with your eyes open to those unknowns. And then I'll share with you some experiences that I've gleaned from what some other agencies are doing in this regard. So the first unknown, as your general manager indicated, that you by statute are allowed to reimburse commissioners for actual and necessary expenses. And it is unknown whether the services of your personal attorney under these circumstances would be a necessary expense for the district as opposed to a necessary expense for your individual, in your capacity as a private citizen. And whether that would pass a legal challenge as to being a necessary expense is just unknown, and it's just something you should just keep in mind as you think about this. The second thing that's unknown is that ultimately, the district is responsible for compliance with the Public Records Act. And allowing a private attorney whose client is not the district and who has a fiduciary duty to ignore the best interests of the district and focus only on the best interests of their client to make decisions as to whether a record is public or not. It is also unknown the extent to which a court would find that to be an abdication of the agency's responsibilities. I can see arguments on both sides of these issues, and I can empathize and sympathize with the obligations that this case now puts on public officials such as yourselves. But these are just things that people are thinking about and that would be unknowns, and unknowns turn into risks. So I'll just say that. Well, what I will say is that the limited experience that I think I'm aware of, and I'm pretty dialed into the community, so I think there's just not a lot, not all public agencies get the same volume of Public Records Act requests as this agency, so there's not a lot of experience out there. But the experiences that I'm hearing are that 90% of the time, I made up that number, a large majority of the time, public officials are able on their own to make a determination that this email is not a public record. It is about my health, about my real estate, about my, I mean, this is just not, or it's not responsive to the request because, as Commissioner Mateusz mentioned, the request is targeted to a particular issue and it's not on another issue. So it may be very time consuming, but that it does not require a great deal of legal expertise or training beyond common sense to determine that a bunch of stuff is going to be in the private side and a bunch of stuff is going to be in the definite public side, and that the gray area turns out to be a relatively small subset of records. And I just know of other agencies who are whose commissioner, whose board members have been willing to take that small subset where they're really not sure, and share it with either the general manager or staff on point, or ultimately with district or city council to make a determination with regards to those particular emails. So if that's a helpful addition to the report, I'll just offer that.
Okay, I have some comments and maybe some questions with respect to this. So, I'm new to this commission still. I've only been at this for 6 months. And one thought I have is that in any public agency where you're asking individuals to serve, like this commission, where you're essentially working for free, really, you want to encourage the public to be engaged in public service because it's an important part of how the world works. With that in mind, if public officials, such as ourselves, are asked to supply their own legal representation, given the premise that everyone in this room, for example, is working as best as they can to comply with what the current states of the law are. So some folks are on fixed income. Some folks don't have high-paying jobs, but they may be brilliant public servants. You don't really want to discourage them from serving under the threat of a potential litigation. So, in my view, it's incumbent on the agency to help protect them. Doesn't mean that if someone is embezzling money out of the district, you've supplied them with an attorney to protect them. That would be ridiculous. But the intent should be, like with respect to public records acts, to provide them what I would say would any reasonable person would deem as protection from legal hassles. And the reason I say this is, in our community, there are folks that have a huge amount of wealth behind them, and they use litigation as a way of getting their way. So you have a situation where they do a Public Records Act request, the commissioner does the best they can to comply, they search their personal emails even knowing that maybe there's nothing there, with respect to whatever the search terms are. You turn them in, they're not happy, they litigate. So the average person, compared to someone who's got a lot of wealth within the community, would not be able to stand under those conditions. You'd have to cave. You would not be able to afford counsel like that. And I can give you a public example, not with respect to PRA, but with respect to throwing your weight around because you do have a lot of cash. There's a suit right now with Vinod Khosla and public access. Well, this individual has a huge amount of wealth and political clout, and he's shown himself to be willing to sue individual. He's sued. There's a suit right now against the head of State Lands Commission, one of our board of supervisors, the head of planning on 14th Amendment rights. Well, you know, if for whatever reason we get in a situation where someone like that is not happy with what we're doing, I personally wouldn't be able to afford it. I'm not sure the district could in the case of Mr. Khosla, but I think you get my drift. So there is a reason to provide some level of protection, I believe, to the commissioners. And I agree with you, you know, if I look at my, especially for me, since I've only been at this a short time, my personal emails that I would have to search is not huge.
Right.
But you or Tom, who have been here longer, would have a long list of emails, and even though you may have done the best you possibly could to comply with how you see the way to use your personal email versus your district email, life happens, and I can conceive of a situation where someone or a newspaper, for example, didn't like your public records request search and would want to force you to give up all your emails. And I realize that the precedents aren't there now, but I can easily see that happening. And I would think you'd want some protection, because it could be a huge expense.
For what it's worth, just there's a fundamental principle of government law, and there are exemptions, but public officials are entitled to a defense by their agency for actions within the scope of their official duties. So I would very much imagine that the individuals you just mentioned as subject of lawsuits are being defended at the expense of their agencies, not at their personal expense.
One would hope.
One would assume.
Yeah.
So I don't think what we're talking about here is the obligation to defend from a lawsuit. We're talking about the legal expense incurred in initial review of records.
Mm-hmm.
Public records.
Correct. So I don't know if that's just, as since you're new, I thought I would
Yeah,
offer you some comfort that you do have
Well,
Well,
some
that's a good
government immunity
distinction.
as a member of this board,
So,
but
let me
with
finish.
subject to some exemptions.
Right. Well, I'm kind of fortunate because I'm only here 6 months, so my emails with respect
Oh,
to
fair enough.
the district are rather limited. But I would imagine that if you're a person that has a huge number of emails to sort through, that could potentially be a burden.
There's no
Well,
question,
sorry.
this case presents, widens the burden significantly. No,
Yes.
there's absolutely no question.
Yeah.
Can I make a few comments?
Commissioner Brennan.
Thank you. So picking up on what you just said, whenever I go to CSDA trainings, they always tell us, don't think just because it says that the district has a responsibility to protect you if you're sued, that's gonna be the case, because it doesn't always work out that way. So I think that's something that we would need a lot more information about. And what I was told is that you can't fall back on that. You could be personally sued. And, you know, I'm not a lawyer, so I don't know, but what you're saying doesn't jive it doesn't match up with the advice that the attorneys that give trainings at CSDA
Like I
have told
said,
us.
there are exceptions.
There
So I
are
do think it does
exceptions.
jive with
So-
what you said.
So is that something that can be put into, so that's the other question I have, is I'm not really clear on what the, when we write a policy, what are the legal implications of a policy? Do you know what I mean? And is there a way to put into a policy,
The risk.
right, a way to mitigate the risk if it happens? But I, see what I'm saying? I'm not quite sure what,
Let's see if I'm understanding you, because maybe
Yeah.
I'm not. I'm really genuinely trying to understand.
yeah,
If the district adopts a policy and a board member complies with that policy,
mhm,
one of the purposes of a policy is that compliance with that policy helps protect board members and keeps them within the umbrella of the type of activities to which they're entitled to a defense. On the contrary, if you adopt a policy and violate it, it probably
Works against
makes
you.
it easier, not impossible, but easier for the district to decide not to protect a board member who is
Right.
violating a policy. Does that answer your
yeah,
question?
yeah.
And that could be subject to interpretation, but
Yeah.
also, you know, if the district adopted a policy that was clearly illegal, you know, would that be something that the district's insurance would cover? Like if it was found that we adopted a policy that violated people's rights because we were saying that they couldn't use certain types of communication, or that their communication had to be filtered through general counsel, and it was determined later that that was a violation of their privacy, how would that be, you know, would the insurance cover that sort of errors and omissions insurance, cover that sort of like malfeasance or bad legal advice? I mean, we are getting into an area of sort of unknown law here, you know, you've admitted that. So it just seems like there's really a lot, there's a lot missing from all of this. But I had a couple other comments. So I know that I personally, my gut instinct, just sort of my gut reaction, is that the whole idea of our staff and the board providing their personal communications to the general manager as specified in the previous policy proposal and the council, just my gut instinct tells me that there's something not right about that from a legal perspective. So I would need to get a whole lot more advice on all of that. It just, you know, definitely seems to me that that would be a violation of people's privacy, because district council and the general manager are not advocates for those individuals, and that's their personal information. And so it just, I would need to talk to some privacy, like maybe we need to talk to the Electronic Frontier Foundation and get them to weigh in on this, because something really broken, I think, is happening here. So I definitely think we need to do some research there and talk to folks about how this may go. And then with regard to tech support, you know, if we're supposed to be providing stuff that's personal, who's gonna pay for the tech support we might need to cull the data, to do the searching, to, I mean, if you've got 100,000 to 50,000 emails, how are you as an individual supposed to reasonably go through all of that and do a good job? You know, I mean, I wouldn't wanna miss something, because if I missed something, and it could mean that it put the district at risk, and that would not be a good place to be. So I just don't feel like, how are we going to know? How can we be confident that, you know, we are actually complying when, you know, it's, the average person isn't gonna be able to, I mean, I don't think I could conduct a search that would be bulletproof at all. So I'm concerned about that. And then also, I don't trust our council to review my personal email. So that's just a, personal concern. I don't trust our district council to review my personal email or my text or anything else. So that's just a personal concern I have, and so that would need to be considered by my personal attorney. I'd have to talk to that person and be like, well, what do you think? This is my gut instinct that no, this isn't a good idea, and I would want to know from them, what they thought, and if they thought it was a good idea, and that would be a fee discussion. It would cost money for that, and so I'm not going to have that discussion because I don't have the money to pay for it. So then the other thing is, staff and commissioners are not lawyers, so we don't have the expertise to make the call on, it doesn't matter about this training. I mean, we simply just don't have the expertise because life is complicated and communications are complicated, and sometimes emails are multiple pages, and there's a lot to be considered there. And then the workload, I think Ed made some good points about, people who are volunteers on boards. This isn't my full-time job. I have a day job. I run a company. And so for me to have to then spend who knows how many hours, dealing with the PRA requests that have already been put in for my personal information, I don't have the time to deal with that. I mean, I've been honest. I have been emailing our staff from day one with that concern, that I just don't have the resources, the time. There's no way I can respond. So, that's an issue. And what happens if, board member can't respond? I mean, what's the fallout? And that's another thing, I feel like I would need to talk to my personal attorney about. Stephen Miller doesn't represent me. He shouldn't be advising me on that. There's supposed to be a clear separation. Our legal counsel is not supposed to be advising commissioners on personal matters, and that's the law. So we're getting into a very gray area here where we're telling our district council to review our personal information. That is getting into an area that I think violates the law, and I would like to get some clarity on that. And then there could be, like, for example, right now we've got a commissioner who's put in a PRA request against two other commissioners. So we've got Commissioner Corrali requesting personal communications from myself and Commissioner Lorenas. And, if, for example, hypothetically, Commissioner Corrali doesn't get the information she thinks she is expecting, I have no idea what that is, maybe she's going to sue the district. I don't know. Would she be suing me personally, or would she be suing the district? That's a question for Stephen Miller.
No, that would be a question for me if it ever came up.
Well,
and if you're trying to get me to withdraw my PRA request, it's not going to work. So.
I'm not trying.
And I'm not the only one who's got
I'm not
the PRA
speaking
request
to you.
in.
I'm not speaking to you.
But you're accusing me of something.
I'm not accusing you.
Yes.
I said hypothetically.
Sorry, I'm out of order. I know.
Hypothetically, who would be sued in that case?
So, I of course can't tell you who a particular person will sue. You could sue anybody,
Right.
even if you're not
That's
allowed
the
to sue
point.
that person, you could still sue that person.
Right.
So, but I think this will answer your question.
Okay, thank you.
The Public Records Act does not include a cause of action against an individual. It allows for a cause of action against an agency.
Right.
There are possible ways that creative litigants could seek to sue an individual as well as a public agency. There are, these fall into the category of the unknowns fallout from this case. There,
Do you have
litigants can be
a
creative.
hypothetical
There-
example?
It's not happened yet, so no. There are ways in which agencies could seek to both immunize itself from and separate itself from a lawsuit against an individual, or conversely, to reach out and defend that individual, as I mentioned to you earlier. So it is just an unknown question right now. I think my personal view is that it's way more likely that the agency will be liable and exposed to risk from the lack of responsiveness by employees or officials in light of this case than that an individual employee or official will be liable. But that is just my personal view based on reading the case and seeing how other cases come down. But that's one of the things that's going to take more litigation to find out. One of the reasons why I'm encouraging you to use district email accounts and to discouraging texting and to making it easy. I'd like to make it easier for the district to comply with records requests, thereby reducing its risk of having to answer these very questions that are reasonable questions, but for which there's just no great answer.
So again, I think we really need to look at what the other agencies are coming up with regards to some of these questions. But we clearly need to move to not using our personal devices, because that seems to be a real problem, and one that, a lot of these issues could have been avoided had we been working off of district devices from the get-go, and I think that we need to fix that problem as soon as possible. So
I believe that's coming up on our next topic.
Right.
So I think
have
that,
some questions.
But I'll entertain one final question on this. That
No, I have a couple
I don't
of
believe that we're gonna get anywhere on this tonight, and I believe that if there's any more information to be gleaned from other districts, departments, CSDA or whatever, we've got a meeting coming up in a couple of weeks. Let's see what we come up with for additional information. But at this point in time, I'm gonna take one final comment or one final direction from Commissioner Crowley, and then I'm gonna ask that this be tabled for the next meeting.
Okay, so Steve Miller, just to piggyback on your, comments about, how commissioners are not necessarily liable because the district is really the agency, right? That in a legal situation, they're the ones who would be liable. Is that correct? Am I understanding that correctly? So
I'm hedging deliberately.
okay.
It's
That's-
difficult to answer these
Yeah,
questions
right.
because
So-
you're presenting hypotheticals that don't
Right.
exist. But ordinarily, under the Public Records Act, it is the agency that gets hit with a lawsuit for its failure to comply. Nobody, I know of no case, I'm confident there is no case where someone makes a request for general manager's communications on the ice cream truck.
right, I get
The
it.
agency doesn't give up the records, and the litigant sues the general manager as an individual. That has never happened to my knowledge.
If a commissioner hires a personal attorney, would that, and again, it's probably not anything that's happened, although I don't know. If a commissioner hires a personal attorney to represent him or her, would that kind of be like piercing the corporate veil and expose that particular commissioner to personal liability, where the person or the agent, the parties doing a PRA request could go after a commissioner individually because that commissioner used a personal attorney? And you may not have the answer, I don't know, I'm just
I
throwing
don't
it out
know
there.
that the use of your personal attorney increases your risk. There's just so many things I don't know. The agency's obligation is to behave reasonably.
Okay,
If a court determines, and I'm cognizant this is being videotaped, so I mean this is just, we're in the land of total speculation. If a court determines that an agency acted reasonably in allowing a commissioner to use their personal attorney. This is an example of bad facts making bad law. If a court would find that an agency behaved reasonably in allowing the use of a personal attorney, but that individual commissioner and their personal attorney did not behave reasonably in deciding what to provide and what not to provide, I think that would be a different outcome than if everybody's maximally being transparent and providing lots of records. So I think it just depends on the
Like,
facts.
yeah, and I'm not expecting a
just-
definitive answer.
I think
mean,
it just would have to depend on the facts of a particular situation.
Okay, great, thank you, thanks, Tom.
You have a motion to
It's a tough,
table?
it's a tough situation.
I'll move,
We have
and
a
this is
second.
to table item C.
Is there a second on item
I'll
C?
second.
Yeah.
Roll call, please.
Commissioner Brennan?
Aye.
Commissioner Lorenz?
Aye.
President Mateusz?
Aye.
Commissioner Chamberlain?
Aye.
Okay, moving on to item D, district-provided commissioner devices, phones, tablets, others. Provide direction to staff. Staff, may we hear from you?
Yes, thank you, President Mateusz. This has come up, and certainly I think that the recent, again, Supreme Court cases highlighted the need for a discussion around this, even though it has been bandied about a bit. So what I did in this staff report was try to run through three basic devices: phones, tablets, and personal computers. We know that we've got policy implications about using district resources for personal use. And one of the options looked at was to not provide any commissioner with any personal devices, and staff doesn't recommend that. So the district provides district-owned cell phones to certain people, and laptops to certain people as well. We adopted policy 6.2.4 in 2005, setting out the rules for use of the district-owned electronic devices. It says in the staff report, and I did highlight this for change, staff is planning to update this policy. Staff is planning to recommend changes to this policy to reflect those technological changes over the last decade. So while we have all expressed interest in being more efficient, environmental impacts of board packages, the convenience of district tablets, which have been adopted by many other agencies, if we provide those district devices, though, we should recognize some fundamentals moving forward, that the district should supply and own those devices. That if available, the district should purchase device insurance, right? The insurance you can get on a cell phone. That other than normal wear and tear, that the holder of the device is responsible for any uninsured loss or damage. That we'll be responsible for the installation of the applications necessary for the conduct of the district business and for necessary backup. That the district device is to be supported by district IT staff only. That the district device should only be used for the conduct of district business. And that there be and recognized a limited expectation of privacy over contents of the publicly owned device. So we looked at cell phones, as I said, tablets, and personal computers. Currently, the commissioners each use their own personal cell phones. They're an indispensable part of both professional and personal life anymore. And the use of a cell phone is just a necessary function. Certainly providing the cell phones to the commissioners simplifies the separation of the district and personal business in voice or text communications. Carrying two cell phones can be awkward. I can speak from experience. One gets used to it, and it's not that bad. So should a commissioner be issued a district cell phone, staff would only then use that cell phone for communicating with the commissioner. So we would ask that the commission consider and direct staff on whether limits should be placed on the cost or type of cell phone. I personally believe the range there is comparatively narrow between, as long as we're assuming that we're gonna be talking about a smartphone, not a flip phone. And then the commission, prior to the development of any policy, direct staff on the frequency of replacement or upgrade. And certainly, I talked about the fundamentals going forward. Staff also believes very strongly that we shouldn't issue any district devices to any commissioner until we have such a policy in place. I can keep going on to tablets and then personal computers, or we can stop and talk about cell phones now, what is the wish of the commission? You want me to keep going through the whole thing?
Yeah.
I'd finish the whole thing and then take a couple comments.
Okey-doke. All right. The issuance of tablets by public agencies to the elected officials has become really quite common. Certainly this is a step towards the paperless board packet that is also getting to be quite common. The tablets can be used for email, for some word processing. They come with attachments, whether it's keyboards, cases. You can attach a mouse to some of them. So in this, I've expanded out a little bit the list of the things that the commissioners should consider and direct staff on. The cost of the type of the tablet. Again, I do think that, within reasonable limits, the range between basic and better is comparatively small in the big scheme of things. Whether the commission should discuss whether the tablets should be enabled with data plan or Wi-Fi only. What additional equipment we should supply, case, mouse, keyboard. Not necessarily at this point, but it could be discussed at this point whether this is a precursor to implementation of electronic only distribution of board packages, and then also, again, the frequency of replacement or upgrade. Staff is, if the commission is interested in staff recommendation, I think staff is certainly supportive of either of these two. Then there's the issuance of district laptops and personal computers. I think here some of the issues are the same, but the range between low end and high end becomes vastly greater and would take some greater care and definition. I don't think that, but I don't think there are any inveterate gamers here, for example, who would say that they absolutely need the very fastest and a 40-inch screen and a this and a that and the other. So we'd need to come in with some parameters on what that district laptop or personal computer would look like. I think the district should discuss and decide whether or not an issuance of a laptop as well as a tablet, or a personal computer as well as a tablet, is redundant. I know that sometimes some of these tablets now, the Microsoft Surface, for example, can very much act as a computer. It's got the speed and the power of a regular computer and the memory. I know that some individuals who have Microsoft Surfaces actually use them with a docking station. So they've got a big monitor and a regular sized keyboard when they're using them. So these are the sort of things that we would need to get direction from the commission on so that we can move forward. But and staff is more ambivalent about that. Staff is in favor of tablets and phones, possibly, but a little more ambivalent about that. This commission could also recognize that not a decision on all three of these needs to be made at one time. We can always revisit. We can certainly, the commission could direct us to come back with policies on cell phones and tablets and revisit the idea of the personal computer at a later date. You can tell us to come back with a policy that addresses all three on the cell phones. Be happy to take direction and answer any questions.
Do you have a request for public comment from Mr. Ullum?
This one I know what I'm talking about. Technology. Pads, for the most part, are useless. Especially if you go with like an Asus or an Android or something like that, they're very difficult to actually make useful. The Microsoft Surface, if I had my choice, I'd throw this thing away in a heartbeat and get a Microsoft Surface, because that is a useful tool. But there is an Apple-centric world, and a lot of people just won't use Windows. The I have a Apple Mac Air, had it for about 4 years, beat the hell out of that thing. I've dropped it off my bicycle going around corners. I have dropped it down the stairs, and I just don't take care of my equipment all that much, because that's just how I am. I can't wreck that computer yet. And I've tried everything to wreck that computer, and it just won't break. It's a low-end config, and I'm a gamer. I would have the best, but I can't give you one reason why I need anything better than that Mac Air, because that Mac Air does everything that you could do short of playing games or rendering videos. So don't cheap out. If you're gonna buy some equipment, spend about $1,000, get a MacBook Air or Microsoft Surface, and this really will solve all your problems with your PRA issues and everything. This is a simple decision, really, man, to do it anyways. You're talking about a $6,000 to $8,000 investment. You're gonna spend that kind of money, aren't we? Just dealing with these PRA requests that we're dealing with on personal stuff, on personal accounts. So there is no good financial reason to vote against doing this kind of thing. Half Moon Bay City Council does it, and they are incredibly good at answering PRA requests. And I can tell you that no one there likes me, but they still answer their PRA requests because it's simple for them to do it. And so, anyways, really think hard about this, but go with a MacBook Air or Microsoft Surface, and you're not going to be regretting it for anybody. So.
Commissioners.
I have a couple of comments. I, for one, like the idea of a MacBook Air or some kind of personal computer, and the other aspect of this is if it's solely for the commissioner use, you could have it set up so that when we come to the district office, we could just back up the files immediately. So you wouldn't have to even request the computer. You just have an automatic backup, and that will solve two problems: one for your PRA requests and whatever. And I did have a question about that to you. In Public Records Acts, we've been talking about emails and texts, but what about work that you do related to the district on a spreadsheet, for example, or a Word file? Where does that land in the world of Public Records Acts?
If it relates to the substance of the public's business, so I don't know what the spreadsheet you're talking about is. If it's a spreadsheet about your personal finances, that would be different from a spreadsheet of analyzing district budgets. But I think if it's on a district laptop, it becomes harder to claim, especially since if you have a policy that says you will only use your laptop for official business. I mean, I'll give you an example. The city of San Francisco is now responding to a request for the internet browsing history of all members of the boards of supervisors during specific
During the
periods of
meeting.
time. And everybody, the public now knows during board of supervisors meetings, which commissioner is on which Facebook page as a
Yep.
result of that. So
That was
using.
just a recent article. Yeah.
Well, the reason I'm asking
Don't
is
get
I'm the
any
treasurer. I might be interested in looking at the district files.
Yes.
And you know, I'm a scientist, so I put it on a spreadsheet, and it's easy for me to look and parse things the way I like to see them.
Public record.
So it'd be great to have a laptop in which, I mean, I bought a laptop that I can use for that, so I don't have I use a Mac at home, but I have a PC for such things, and it just makes it easier to keep it separate. But it'd be great to have a district machine that, like, come into the office, back it up. It solves two problems. One, you get everything that I've been working on with respect to the district, and the other is it's backed up. And the other aspect that I think is important in any of these devices is virus protection software.
I didn't mention that anyway.
That's That's my view.
Any other commissioner comments?
Yep, I got some. So, yeah, I agree, virus protection is important, whether, regardless of what type of device it is. And we haven't talked about software. You know, there needs to be all the basic software that one would need to open files on the device. So that's, you know, I wouldn't
Yeah.
want to end up with a device that didn't have Microsoft Word on it or something, or Excel, or where I couldn't open district documents. So that, I just want to make sure that we mention that, because that's not discussed here. I mean, it kind of goes without saying, but I think we
Yeah.
should say it. So, I am a diehard Apple user. So if I get a Windows device, I'm gonna give it back to the district because I'm not using it. So that's definitely not working for me. So I just want to put that out there, that like I only use Apple and that's it. There is no other option for me. So if the district were to provide me with Windows device, or, you know, some smartphone that wasn't an iPhone, I'd be handing it back because I just don't want any part of that. So I think it's important that the commissioners are provided with devices that they'll actually use. And I think they are all in a similar ballpark of price, and so it's pretty standard these days what the equipment is that's out there. You know, we want to get what's current. I do not use iPads, and like I said, I don't use anything other than Apple equipment and won't. But I'm not a iPad person, and so I don't want an iPad. If that's going to happen, don't bother getting one for me because I don't want it. I do use laptops, and I would definitely find a MacBook Air useful. I think they cost $999. It's like $1,000 for a machine, and I do a lot of writing with regard to the district. I write a lot of notes. I do Excel spreadsheets. I, create reports. I write letters. There are all kinds of things that I do that require a laptop, and I find that an iPad is just, it just doesn't work for me. So I just want to make that clear. So I do think we have to be responsive to providing equipment for people that they will actually use productively, and I think that goes for our staff too. I don't think we should have equipment that we put upon our staff that isn't the preference of our staff. And so I very strongly want to recommend that we have some sort of policy going forward where our staff helps dictate the type of equipment that they receive when they come to work for the district. Otherwise, we're not going to have good staff retention. I know if I went to work somewhere and they gave me some machine that I didn't like, I'd be looking for a new job. So, we use these machines so much, and they're so much part of our life, and we spend so many hours on them. We need to make sure that we've got devices that work for our work style, our learning style, all of those things. So I strongly support having a policy that provides flexibility for the commission and for our staff in making choices. Obviously, I wouldn't support someone who wanted to buy a $5,000 computer if all they really needed was a $1,000 laptop. Obviously it's got to be within reason, but at the same time, if spending an extra $200 makes their work life better, then I think it's worth it to do that, because we need to be productive and we need to be effective, and to do that we need to have good quality equipment that we like working with. So I strongly support phones, whether it's a smartphone that's not an Apple or an iPhone, whatever the commissioner decides they want. I support phones. I support giving the commissioners a choice. If they prefer to work on some sort of a, what do you call those pad things? There's the iPad, and then I don't know what they call
Microsoft Surface.
Surface.
the Surface,
Surface.
whatever it is they prefer. If that's what they want, then work on that. If you prefer to work on a laptop, then work on a laptop. I don't support both. I don't think at this time we need to have an iPad and a laptop. You know, at some point down the road, when the world changes and technology changes, maybe that is gonna be, maybe there'll be some other third device that you can't live without. But I think for now, 2 devices is enough, and I think that's gonna go a long ways towards sorting out the problems with our ability to respond to Public Records Act requests. So that's where I'm at with it right now.
I have a couple of things.
Commissioner Corrali.
So Steve Miller, I just want to make sure that I'm understanding correctly, that just because we get these district-issued devices, that doesn't mean that the California Supreme Court ruling is still not effective. It's effective. That means that anyone can still do a PRA request for your personal texts and stuff if they believe that there's, is that correct? If that's not necessarily on the district-issued devices, computers, phones, whatever.
Yes, that is correct.
Okay.
And this may not be the question you're asking, but I'll answer it anyway, which is, it would be legally problematic to use your district device for personal use.
Okay.
So that your personal use and your personal emails should not be conducted on your district-provided device, but should be on your separate device.
And that
Okay.
is the whole point.
Right. And then the other thing is, I agree with Commissioner Brennan about having choices, because I will never use any Apple. I've never used it, that's just me, and I never used an iPhone, I've never used Apple devices, and I actually agree with the member of the public about that. So, and I've actually turned equipment back, because I just can't use the iPads or whatever. That's just, I guess we just all think differently and use things differently. So I don't know what kind of thing we can, how we can do that. I mean, maybe if it's, I don't know if it has, how it ties in with the
You can
district
get every-
system.
I don't think
When you talked about
Is it gonna be an
$4,000.
issue?
I don't think.
I mean,
it's-
because if you
No.
listen to what Ed said, and I agree with in terms of the backing up, I mean, you don't have to use,
Yeah.
like, if
We'd have to
everyone
figure
wanted
that-
an Apple except me, could we still
It
do
wouldn't
that?
matter.
Yeah.
Okay,
it-
I just-
No, not an issue.
Okay. Thank you.
Well, I think that, since I use both Apple and PC type things, the PCs now accept all the iOS apps, and you can do everything on your computer that you can do on your Mac. And likewise, I know there's fairly good convertibility from pages and numbers to Excel. I thought coming into this discussion that I'd say, let's pick a brand, a model, and everybody have it. That probably makes too much sense, judging by the definiteness opinion of some of our board members. So I would say that we have a price range, we set a limit. All these things are gonna work. So it doesn't matter who's prejudiced against what. The software companies have figured this out. Apple wants your Microsoft business, Microsoft wants your Apple business. If we pick, for instance, the $1,000 mark, whatever that is, I think the one thing we could rule out, and I would ask the board to agree, we don't need a computer. We're not gonna be able to bring computers to the meetings.
Yeah, I agree.
We're not gonna bring computers to our cars and so on.
You mean the PC?
So the absolute rollout would be personal computers, desktops.
Right.
Yeah, I would
So
agree.
then whether you
with
call it
Yeah.
a laptop or a tablet or whatever, would we have agreement in the board, no computer? Now we're getting into the weeds, laptop, Air, whatever you call it. So,
I'm certainly hearing consensus. I've been very little discussion about phones, but
Oh,
I think I'm getting,
I think that we're pretty much.
okay, consensus on
That we
phones.
probably need a phone, but it's
Okay.
a matter of iPhones or Android.
Well, and I think what staff would do, is we'll draft a policy, and we'll look at a price point, and we'll
Yeah.
present you on a
Yeah, the
periodic
choices.
basis, whether it's every 2 years or 3 years or whatever. Here's your menu, pick which one you want, and certainly, I recognize the different opinions about the different platforms, and so we'll make sure that both platforms are represented. So I'm getting consensus on phones, and I'm getting consensus on
No PCs.
tablet or laptop, commissioner choice, but not the desktops.
Right.
Correct.
And not both tablet and laptop.
Correct.
Right, one or the
Okay.
other.
So given that, is the commission comfortable with the enumerated issues under background? That the equipment will be district supplied, known, and so on and so forth?
Yeah,
Yeah?
I am,
And-
but I don't know, I'm not gonna speak for the others.
So
It-
just to reiterate, what you're gonna come back, I wanna make sure I understand what's coming
Mhm.
back. So what's coming back is a, proposed draft policy
Yep,
which would allow commissioners to select up to 2 devices, and that
Yes.
would either be that would be a phone, that's sort of a given,
right,
and then the choice for the commissioner would be whether they wanted to go with some sort of a tablet type thing or a laptop type thing.
Right.
Those are the 2 choices.
Yep.
Okay. And then it wouldn't be like, I don't really want to get into a big debate about the cost of this versus the cost of that. I think we know what the generally accepted equipment, there aren't that many choices out there. I just don't want to, and I also think we need to think about this in terms of our staff too. And I'm not saying that this policy, maybe it could be written so that it applies to staff. I mean, maybe we need to look at that.
This is actually what happens with staff, though. I mean, I
Right.
need a pause coming on what kind of computer we use.
So you do ask them?
Absolutely.
Okay, that's
Absolutely.
good.
And we did, in fact, we tried something over at Oyster Point in tablets, and they didn't like them, so we brought them back.
Okay,
Right.
so we are being flexible
Yeah,
about that.
absolutely, absolutely. So, and again, I wouldn't like to see the policy, the proposed policy, be too prescriptive, to your point about you get this amount of dollars. I'll try to come up with some language that talks about the midpoint or some way of describing a device, and separate from the policy. Here's your menu, pick which
Okay.
device you want,
Right,
Yep.
right?
all within a price range,
And I
like
think,
about 1,000-ish, I
yeah,
think
and I
that's
think phones
reasonable.
are what, how much are,
I have no
phones are gonna be in the $500 to $700 range?
That's right, $750. People with iPhone, you're gonna spend $750, so that means you're gonna have to buy a Samsung 8 for everybody else, because they're gonna want a $750 phone too, so.
Impeccable logic.
Yeah,
It
well,
works, that's the truth.
I just want one that works.
I just want,
I don't care.
I like to be able to reach every part of the screen with my thumb. But anyway, I'll come back with menu choices. We know roughly where we are on the phones. We know roughly where we are on the tablet slash
Laptop.
laptop. Let's see, tablets, just a data plan or Wi-Fi. I would assume that if it's a tablet, we would provide one of those little folding cases just to protect the screen. If it's a laptop, we provide one of those little sleeves that it fits in.
I think too that for-
Phone charge, I mean, a car charger for the phone.
if the person's getting a tablet, which, as I made clear, will not be me, but if that's their choice, I think they should also get the accessories like if they need a keyboard or something, they should be able to get that stuff too, because.
Consensus?
Oh, yeah.
Yeah.
I mean, I
Yeah,
just
they're
think,
fine.
I
Yep,
think that
sounds
if the
good.
goal is to make this easy for commissioners to use, then we need to make that possible
Got it.
as best as we can. I mean, within a certain
Yep.
cost parameter.
Very good. I'm on it.
Okay. So you have your direction for item D,
I
right?
have my direction for item D.
So I'll move to adjourn.
A second.
I'll second.
All in favor?
Aye.
Aye.
You
Okay.
can go home tonight, everybody look up Bobby Petrino, coach in Alabama, who got caught in a motorcycle accident with a girl he shouldn't have been with. And the way he was exposed is the AP guys knew enough to ask for a FOIA request. And he was using a cell phone that was provided by the university. So they had to provide the texts that were on the cell phone.
Oh,
And
man.
Mrs. Bobby Martino was not happy.
Thank you for that.
Steve,